Hello, and welcome back to Coin Lady channel. So Law Professor Coin Lady channel thinks the SEC is trying to prevent you and I, and the public at large, from transparency that is required by law by making some sneaky changes in an attempt to get around what ultimately led to, well, the revealing of the Bill Hinman emails and dress concerning his theory of free pass speeches in the considering that, Bill Him and he offered his little disclaimer that, okay, this speech, it's just my own opinion. Given that it didn't involve deliberative process privilege or any kind of pre-decisional wrangling, it's a significant reason why it was eventually made public. The Securities and Exchange Commission was only one factor among many. This law professor claims that the SEC has devised a mechanism to prevent the public from ever again having access to such a wealth of information. And I know that Attorney John Deaton has some thoughts on this as well. However, it should be made obvious that I do not come from a legal or financial background. I am not qualified to give you financial or legal counsel. And you shouldn't make any financial decisions based on what I say, right? Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. Okay, so this is the professor of law with whom Ben Edwards had an issue. His thoughts, which may be found on this page of the Business Law Professor blog and are relevant to the SEC versus Ripple case and Billy Boy Hinman, are as follows: SEC updates opening disclaimer, perhaps in response to discovery debate. My career has been marked by a departure from the customary beginning used by SEC commissioners and staff in public presentations. This is always the opening line of their comments. The views I share today are my own and do not represent those of my other commissioners or the staff. I must make this standard disclaimer before I can begin. On March 30, 2023, Commissioner Crenshaw gave the typical disclaimer in the beginning of her remarks to the Fixed Income Forum by using this very case. And Chair Gensler a month ago or so. Normal disclaimer: the Small Business Forum was published as a quotation on April 24, 2023. As is customary, I would like to state that the opinions expressed here are my own. I'm not quoting anyone from the Commission or the SEC when I say this, but things are different. On May 10, 2023, the chair arguing against her worded the disclaimer thus. So, have a look at how things have evolved in the past 2 weeks. When asked about his opinions as SEC chair, he said, "My views are my own." This was in his remarks to the Municipal Securities Disclosure Conference on May 10, 2023. I cannot speak for the other commissioners or the staff when I make this statement. What do you think they're up to over there, folks? These views are shared by many people, not just me. Hey, I'm the chair of the Securities and Exchange Commission, SEC. Your thoughts remain no more valid than mine. I am speaking in my official role. In the event of a lawsuit in the future, please let me know your thoughts on this. Nothing related to my velocity could be uncovered. Because I'm speaking in my official capacity, I'm hoping. Right. This is simply my personal viewpoint. I mentioned that I am the SEC's head of administration. That pretty much seals the deal, no? You can see the reasoning behind it, so make sure. Look at this. Ben, a professor of law, persists. Chair Ginsburg's statements to the Investment Company Institute today reflect this modification. As always, I'd like to emphasize that in my capacity as chair of the Securities and Exchange Commission, I'm expressing just my own opinions and not necessarily those of my fellow commissioners or the SEC staff. It seems the convention has shifted, as the introductory disclaimer now includes a notation that the comments are being made in an official role, as shown in the cited example. This is also reflected in Commissioner Hudat's May 16 remarks at the NFA Global Conference. Quote, I would like to share remarks that reflect my views as an individual commissioner of the SEC and do not necessarily reflect the views of the full commission or my fellow commissioners. Disputes over discovery undoubtedly led to Mr. Language's removal as chair in SEC versus Ripple Labs. According to certain media outlets, Former SEC Director for the Division of Corporation Finance William Hinman was subpoenaed to release records connected to a lecture he gave in 2018. When I looked into the issue further, I found an order that said internal discussions concerning the Hinman speech were not shielded by the DPP and may be discovered by the court. Because Hinman was expressing his own views, and because those views do not relate to any form of agency position, decision, or policy, the following wording from the opinion is pertinent. What he is emphasizing here is taken verbatim from the ruling of Judge Annalisa Torres. This instruction came from her on September 29, 2022. The passage from Judge Torres that he has chosen to quote is as follows. Documents expressing advisory opinions, recommendations, and deliberations that are part of the process by which governmental decisions and policies are produced are protected from disclosure under the DPP, a type of executive privilege. Deliberative documents fall under the DPP's purview since they are created before a decision is made. If they were created before the agency made its final decision, and if they were drafted to help the agency decide how to proceed, then they qualify as deliberative. Judge Net Byrne ruled that the DPP does not apply to the internal speech documents because their purpose was to facilitate the communication of Hinman's own opinions regarding the application of the securities laws to digital asset offerings, and not the opinions of the S2C, the SEC argues. That Judge Nepenthe's conclusion constitutes an error of law, as Second Circuit precedent states that subjective documents which reflect the personal opinions of an individual are not subject to the DPP. However, this line of reasoning ignores the fact that such subjective documents enjoy legal protection only when they pertain to official agency positions, decisions, or policies. Since Judge Nutborn found that the internal speech documents were unrelated to any stance, judgment, or policy of the agency, her ruling was not in violation of the law. What Judge Torres said. Now you understand the goal of this. Law professor Ben Edwards is suggesting that this is the case, and I can see why he could come to that conclusion. I mean, think about it, it makes perfect logic. Well, I guess we'll find out if it helps. You might make the claim that you are acting in your official capacity. The context seems to be professional, yes? Intensive labor. But that's just me, and the SEC isn't responsible if you don't agree with my assessment. You notice a sneaky, I'm telling you, these people are slime, they do not want you to have a proper relationship with your significant other. Degree of openness. That is really straightforward. In all seriousness, when it comes to him and all that jazz. That's what the plaintiffs in SEC versus Ripple battled the hardest to prevent. They didn't put up much of a fight at all, and they didn't even win. The fact that their immoral behavior and intentions were exposed was obviously the thing that concerned them the most. Now they're being dishonest in order to cover their tracks even more thoroughly. And time will tell if future judges are fooled. Then, Ben says something to wind us up by saying we've come full circle. This is probably why the disclaimer has been updated to include a declaration that the comments are being made in an official role. I can't say whether or not other litigants will have the same luck as Ripple in obtaining access to confidential company records. However, I anticipate that the defendants will attempt to argue, if they can find a way, that the records should be released in discovery. This is an intriguing viewpoint. Here's what John Deaton, an attorney, has to say about it. He cited a piece by law professor Ben Edwards and author John Deaton on the distinction. The SEC attorneys' dishonest and conflicting stances on the speech led to the records containing human speech being declared discoverable and not privileged, despite the disclaimer. So, let me pause for a second to say something. Unless I misunderstood the first tweet, in which case I agree with everything you're about to hear from John Dean after having just posted that excerpt from Judge's speech. I'm puzzled as to where he gets that idea from. Really and truly. Perhaps there is something I am overlooking. If, however, you need a reminder of who or what Judge Torres is and where they are after reading, the information is conveniently shown on your screen. I won't be rereading it. They seem to have everything to do with the fact that Bill Hinman's statement was ruled to be merely opinion and not a foregone conclusion about the SEC's position on a particular issue. But then again, I might be misunderstanding John's deep thoughts or his intended message. That, too, might be my atmosphere, pal. I figured I should make that clear. After this point, however, I agree with everything he says, because he is right to call attention to the SEC's duplicity and malicious intent. Despite Hinman, Clayton Hester Peirce, and other high-ranking officials saying it was market guidance, Attorney Deaton writes that they hurried to argue that it wasn't. Lawyers for the security industry moved quickly to have Hinman to swear in an affidavit stating that his remarks were his own views and not official policy. So, do what Spot says. What your tour ultimately discovered in Judge Snapper was that this is only Billy Boy Hinman's opinion. But if the SEC, and you can see the schedule, and keeps emptying the spaces here. His main argument here is that the SEC could have avoided further confusion by sticking to the original version of events. We've never tried to hide the fact that this is official SEC business until a decision was made. If that didn't happen, then maybe we'd never see the Hinman emails. It's due to the SEC's inability to take a unified stance. Solicitor Deaton goes on, anyhow. The goal of the SEC lawyer was to strategically undermine the lack of fair notice argument made by Ripples. Having established that what Hinman had to say was not advice, but rather his own viewpoint. According to Judge Nepean, the deliberative process privilege did not apply, hence the speech was discoverable. Besides the Hinman emails and speech drafts, Judge Nepper decided that everything else Ripple had sought discovery on was privileged. People must be considering that. Alright, so I went on the hem and sent some emails to try to get the word out. Whether it would have any bearing on the case at all remains debatable. As indicated by Attorney Deaton, Judge Nepper found everything else Ripples wanted discovery on was privileged, and I recall those discussions from when we were trying to determine if this was something that would ever see the light of day. If the SEC had taken a different position in this case, then the Hinman emails probably wouldn't exist either. The SEC's lawyers, according to Attorney Dean, then claimed the documents were protected by attorney-client privilege, claiming they would not risk their integrity or the law to do so. Immediately, they set out to collect further affidavits from current and past SEC officials, including Hinman once more. It was now claimed that Hinman was a client of the firm seeking counsel. And all his co-workers were lawyers, giving him advice on his own personal perspective of the law, to which he responded with a facepalm emoji. And I've always thought the SEC's defense of its actions was hilarious. Who could possibly believe this? To whom do we address Bill Hinman? He has expressed his own opinion. This is a speech, by the way. But all the other drafts and emails preceding up to that were him consulting a lawyer. He plans to see a lawyer before expressing his viewpoint publicly. This is probably the most amusing example of the SEC's stupid-ass reasoning, and it obviously didn't work out for them. That's what your coworker's legal counsel said, anyway. Unusual faith is shown here. Attorney Dean claims that during a hearing on the subject, the SEC dug itself an even deeper hole by arguing that Hinman was acting in his official capacity as director when he gave the speech and that the speech reflected the opinions of not only Hinman, but also of the Division of Corporation Finance. Look at all these doctors we have. Therefore, your judgment of Titman may differ from mine. This is not his opinion at all. He has consulted an attorney. Oh, and By the way, now we're contending that it's an opinion from the Division of Corporation Finance as well as the Tenements Department. Judge Nepper and called the SEC lawyers out in open court. An arrogant Attorney Deacon continued to argue that more than simply the Division of Corporation Finance had impact on the Hinman speech. The U.S. crypto law transcript includes my presence. The court remarked in his conclusion that SEC lawyers lack faithful allegiance to the law, and he also commented on the SEC's hypocrisy. Ouch. Also, I'm going to read this, because the highlighted section has my favorite writing by Judge Nepper or Taurus. From the desk of Judge Nepper. The SEC appears to be adopting its litigation positions to further its desired goal rather than out of a faithful allegiance to VOWA, given that it has argued to the court that the speech is irrelevant to the market's understanding of how or whether the SEC will regulate cryptocurrency, while at the same time having sought and obtained legal advice from SEC counsel in drafting a speech. That's the best line anyone said in the past 2.5 years, and you gotta love it. So far, that's my absolute favorite part. Maybe some more gems will be included in the summary judgment decision, but for the time being, that one is tops on my list. When asked why the SEC or the emails or other evidence were ruled discoverable, Attorney Deaton concluded by noting that today SEC lawyers can engage in denial all they want. The documents would likely never be made public after June 13, even if the companies involved had SEC enforcement lawyers who told the truth. Therefore, I believe I understand Attorney Deaton's perspective. Unless I'm missing something, I take it that what he's trying to argue is that the SEC could have avoided this whole mess if only they'd been consistent and stated categorically that they never, ever considered Bill Hemmons's views to be anything more than simply that, his own. If only they'd started off with that attitude. There was overwhelming proof that this was a pre-decisional stage, therefore we knew we wouldn't be receiving the necessary paperwork until after June 13. The 13th of June seems to be the most likely date. In principle, it could be sooner, but that would be missing the purpose. Just thinking about that makes me want to do it, but then again, that's what I was saying a few minutes ago if you consider the conclusion. In my opinion, that's just an additional safeguard. So, unless I'm missing something, I agree with law professor Ben Edwards. Please tell me in the comments if I'm wrong. I won't lie and say that I always hit the nail on the head. However, that's how it appears to me. Even though I don't have a legal background or education, I found Professor Ben Edwards' explanation of Attorney Deaton's point of view fascinating and appreciated the opportunity to think about the concept. This isn't the kind of thing I would have seen on my own. Then someone pointed out my error and said, "You sneaky sons of bitches," I couldn't help but laugh. To be clear, I am not a professional financial consultant. Nothing I say should influence any purchases you make for yourself. Please like if you enjoyed it and subscribe as always. See you later, bye.